let's get into the topical stories today. It's time for our big stories. We're going to be talking about the Assin North development. We'll also be talking about inflation, which for the first time in quite a number of years has hit a peak. I will be giving you details of that. But joining us, Roxanne Nelson Dafiamekbo, Member of Parliament, South Dai. He joins the conversation this morning. We also have joining the conversation Mr. Gary Nimako, who is with the legal team of the MPP. We have Justice Abdullahi, who is a lawyer, Kojoga Daudu member, NDC's legal team. All of them join us for this all-important conversation. Let me just add that the Member of Parliament for South Dai, Roxanne, is also on the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. But before we get into the nitty-gritty, I know you want to do this. Easter is coming, and you want to say something to your constituents.
Yes.
What is that message?
Now, thank you very much. Let me use the opportunity to wish my people in South Dai, Peki Bali Beve Tongo, the very best of the Easter. I'll join them tomorrow. So starting from Peki, Dega and his people in the Peki state, Peve Togbe Akudumpe, Togbe Agbinani, and the people of Zendo. My greetings also goes to the Kpali people, Togbega Atiklaja, and his Kpali people. Then Tongo, Mama Tomelo, Togbe Ajado, and the people of Tongo, traditional area. My regards to them. Right. My regards to pastors like Afotude of Germany, Pastor Arnold of Peki, and all. I further send my greetings to the market women in Germany, Beve and Peki, because they have sustained us throughout the year. And of course, my party people, the NDC executives, the Constituency executive, Constituency Chairman Prince, my regards, organizer, Fumoji, I greet you, and my branch executives and the chairman who are working hard. And of course, I cannot leave out my chief executive, the Honorable Dajawa, the newly appointed MPP Vice Chairman as the District Chief Executive for South Dai. We are beginning to work together very well, and I hope that this can only get better for South Dai. So on this note, and of course my drivers, my Okada boys, and my two police commanders, a Peki police commander and the Kweve police command. My regards, fire service commander, and my SMO, senior medical officer at Peki Government Hospital, Dr. Cranton, and all the farmers in South Dai.
Okay.
I wish you all the best, and I'll join you tomorrow.
Ayo, we thank you for the public announcement. Member of Parliament for South Dai, Roxanne Nelson Dafiamekbo there. Let me just let you know that we're also going to be checking out the feel of, those in Assin North, that constituency, how they are reacting to the latest ruling by the Supreme Court. We'll be getting some snapshots of interactions with them. We'll also be hitting the streets today to gauge how you feel about the inflation that has affected everything from food to everything else that we purchase out there. So just stay put. We just might come to a place close to you. Let me also say a very good morning to Justice Abdullahi, lawyer. He's been in the public space a lot recently on the back of that petition or case he brought before the Supreme Court in terms of Parliament, quorum, deputy speakers voting and all of that. Justice Abdullahi, a very good morning to you.
You too, and indeed, good morning to my good friend, Roxanne. And I understand you mentioned Gary is also on the line. Gary is also a brother, so I greet them. But I am very excited about the way Roxanne has been very consistent. Every time he appears on the program, he takes the opportunity to greet his constituents. And for me, the consistency has been very, very keen, and I love him for that. I think our honorable members should be learning for that. I think that you have roots that you ultimately go back to. And so when you're taking decisions, you remember the people who brought you to where you are. At the end of the day, all that we are doing is for the good people of Ghana. It's for our posterity, and indeed it's for all of us. So every time you back to greet the people back home, you remember their poverty status. You remember how struggling, how difficult they are all struggling just to make ends meet. I think that is the best way to put that thinking, that patriotic thought to the wheels and make better decisions that are near to the benefit of our collective good and not sectional interest.
Right. Let me just let you know that Gary is on with us, but not online yet. He's not connected. So he may not have heard what you said, but I'm sure he'd be appreciative of everything you've said so far. Justice, so let me start with you very quickly. Let's start with the legal elements of what we are facing now. Assin North, the Member of Parliament, or should I say the former Member of Parliament? Well, not yet. It's a bit murky, isn't it? But he's been stopped by the law from holding himself out as a Member of Parliament and performing parliamentary functions like going on the floor of Parliament, participating in debating, voting. Obviously, all those are now thrown out of the window on the back of the Supreme Court's ruling. What is your quick take? I'm sure you've taken a look at the ruling and the ratio of the court. What is your reading of this, especially as, for now, it's not a unanimous decision like in your case. It is a 5-2 decision. Hello, Justice.
The decision from the High Court all the way up to all the applications that were thrown out.
Okay, we seem to be having some challenges with Justice Abdullah's connection. We'll try to work that out, and when we have it sorted, we'll get to him. But let me say, Gary, are you with us yet? Gary DeMarco? All right, so Gary cannot hear me yet. Gary cannot hear me yet. When he connects, we'll get to him. So I'll start with you, Roxanne. Yeah. And we've heard from your legal team, and they've not been happy with this ruling. But I guess everything was pointing towards that on the back of the Cape Coast High Court's decision, which now the Apex Court has upheld. But what is your reading of what transpired in court yesterday?
There appears to be a lot of confusion surrounding the issues about Quayson. So
the substantive one is still being contested.
Let me clarify.
Right.
Or let me take you through the morass of cases involving him. The matter that was heard yesterday was an application on notice for an interim injunction.
Right. Interlocutory injunction.
Yes, interim interlocutory. To be granted in respect of him. Pending the determination of a December case that Frank Davis filed on behalf of the plaintiff. What is that case? They are asking the Supreme Court for an interpretation of Article 94, Clause 2 of the Constitution. Basically to say that at the time that he got elected, he owed allegiance to another country. Because 94.2 speaks of allegiance. Now, that case is not yet determined.
Right.
By the Supreme Court.
Which has been made clear. I mean, yesterday we heard that made clear.
It's not been determined.
Right.
But what the Supreme Court has done is to injunct the member.
Right.
That until we determine the matter, do not hold yourself as the MP for Assin North.
Right.
Which is a big shock.
A big shock?
Yes, because you see, by the court's own decisions, you do not injunct constitutional office holders.
Where let's stretch this. Where constitutional office holders are whom?
Like the president.
Like the president?
Yes. If somebody gets elected as the president and somebody disputes the election and you go to court, the person who gets elected is not stopped in his tracks from acting in that office until the final determination of the matter. You understand me? So you do not stop an MP from serving in that office until the final determination of a matter. Because you see, the grant of an interlocutory injunction is on the balance of the equities. Who suffers the greater damage? Now, if the matter is determined and it favors Quayson, what would Quayson have suffered for the time that he's been stopped from serving in his office as the Member of Parliament, and by extension as the elected representative of the people of Assin North? So the thousands in Assin North would have suffered the greater damage. That is why, by the tenor and terms and spirit and letter of our Constitution, whatever that person is regarded to have done is regular until the court pronounces otherwise. Because the grant of an interlocutory injunction, it simply means that it's an interlocutory remedy. It's an interim remedy. Right. It's not a final decision.
Right. And this is often employed in cases just to ensure that maybe one party doesn't have a certain advantage, or the other is not put at a grave disadvantage,
exactly.
and all of that.
But in this case, a plaintiff is simply asking the court to give a purposive interpretation to a provision in the Constitution. So who will suffer the greater damage? The person who has been installed in office, taking the oath of office, and is working, or the person who is seeking that interpret this, and if it goes in my favor, I take a certain decision.
But how about let's take Nympha, the petitioner.
Yes.
Let's put him aside.
Yes.
And look at the law. Yes. The law itself stands, and it can also bleed or be affected in terms of certain actions if they are not remedied. And that is exactly what Frank Davis was pointing to. It is illegal. His being outposed is illegal, per his words. And so it is only right for the right thing to be done at this point by letting go of him till the proper processes are followed. And if there's going to be a by-election, fine. If he's going to be reinstated, fine. But in the interim, the breach of the law must reflect.
Can I answer Frank Davis? Who determines that the law has been breached? Him? No.
The courts.
Exactly. It doesn't.
But the courts have granted the injunction.
Hold on. It doesn't lie in his mouth to say that the law has been breached. He can only complain.
Right.
You have sent a plaint before the court. The court is yes to. So what it means is that tomorrow, for instance, if I raise issues about the appointment process of some Supreme Court judges, that I have evidence that the processes that led to the appointment, which is several stages, are fraught with certain things. So the appointment, therefore, is unconstitutional. If I file a matter such as that, then I bring an application and say that the court should injunct the Supreme Court judges from acting as Supreme Court judges. Is that what we are saying?
But let's not.
No.
Hold on. There's a reason I'm saying this. Supreme Court justices or justices of the higher courts or the superior courts enjoy, security of tenure.
Hold on.
They enjoy security. So let me just make my point. Let me make my point and react to it.
Okay.
They enjoy security of tenure. Of course, it doesn't mean they are above the law because there are certain circumstances under which they can be removed.
That's not what I'm saying. I'm saying the appointment process.
Yes, but I'm still going there. But I'm saying that since they enjoy security of tenure, even if you have such an issue, would you not have to conclude the legal processes like the announced expose, for example, some of them?
Yes.
That bordered on judicial corruption.
Yes.
Certain processes went through. We didn't just sideline them. And at the end, when it culminated in certain evidences provided or evidence provided that pointed to the fact that they were complicit, then certain actions were taken. Correct me if I'm wrong.
No, you are wrong because they were suspended.
No, it's not all of them.
They were suspended.
It wasn't all of them.
How many?
Because I do recall that some of them, had to, but not all of them. That's the point I'm making.
It even buttresses the point.
Right.
That when somebody occupies a constitutional office, you don't injunct him pending the final determination of a matter on its merits. The matter in question has not been determined on its merits. So how do you take away my rights? Because somebody is making an allegation which is yet to be proven? And people are confusing this matter with some other cases that are also pending. You understand my point? So I have a big problem with the decision that was given by the court yesterday. Very, very big problem.
Are you saying that fundamentally
it's erroneous?
The court, which is clothed with the power of interpreting what the Constitution says.
The court hasn't done that.
Hold on. In this regard, because flowing from what the Cape Coast High Court did.
Agbeku, take your time. Akaku, take your time. I apologize.
I'm going to see you one of these days for
Akaku, take your time. What I'm saying is that the court has not even interpreted the plain before them.
I get
that. What they have done is to have exercised a certain discretion, which is inherent in them.
Right.
And in
which is the point I'm making.
Yes.
They are clothed with those powers.
Yes, exactly. So in exercising that discretion, they have granted a certain remedy, an interim remedy, to favor the plaintiff and to disadvantage the third defendant in the matter, because the plaintiff went against the AG, the Electoral Commission, and Quayson, to disadvantage Quayson in the interim. And that will be for how long? If Quayson stays away for, let's say, 2, 3, 4, 5 months, and the matter is eventually determined, and the interpretation favors him, how is he going to be compensated for the 5 months?
Is that to say that you feel James Quayson has been hard done by the courts?
In fact, by our jurisprudence, this is the first that a constitutional office holder will be injuncted. And mind you, I made a point yesterday, and somebody said, I think you are right. To injunct him doesn't mean you have removed him.
Of course, it's merely an injunction.
Thank you. You have not removed him from office. In
terms of performing certain functions.
Exactly. And so
but he still remains member of parliament.
Yes. So those who are running around and talking about by-elections, they don't understand the law at all.
I think it was Baba Jamal who also said post the decision in court.
We haven't got into by-election at all.
That is not the case.
Now,
but we've had even the Attorney General, and corroborated by Frank Davies, say that
exactly my point.
Basically, the EC has the green light to go ahead with the by-election.
EC hasn't got the green light. Read Article 97 clearly. They haven't got the green light. Are they saying that the matter that Frank Davies himself has filed has therefore been determined? Is it not premising?
That is the pending substantive matter.
You have premised your application on a pending matter. The application has been granted in your favor. Then you run to town and begin to make pronouncements as if the matter has been finally determined on its merits. And I find that conduct very, very reprehensible.
Hold for me. Let me bring in Gary Nimako as well. And I'll come to you shortly, Justice Abdullahi. But Gary, thank you so much for joining the conversation from where you are. I don't want to mention where you are, but we're grateful that you've taken the time to join us. Right.
Good morning to you. Good morning to your listeners, and good morning to Roxanne and Justice. Roxanne, you are too hyper this morning. Just know that.
You know the things you are doing. You know the things you are doing.
Slow down.
You too slow down.
Gary, what things are you doing that are upsetting?
The political savagery is too much.
What things are you doing?
The political savagery is too much. You know what I speak of.
You see, my brother, let's understand something. We live in the country is governed by rule of law and by our constitution. Now, we went for elections. Post-election, even before the elections, there were people who had gone to complain to the NDC hierarchy. And the gentleman, Mr. Quayson, at the time of the internal primaries, was still holding on the Canadian citizenship. This is an open knowledge. Yet they ignored it. All the warning signs were there. They ignored it. Now, he stood for elections. He won the elections. There was a challenge about eligibility and qualification criteria on his part. It went to Assin, the Cape Coast High Court. The court granted an injunction that pending the resolution of this matter, please, Mr. Quayson, don't go and let yourself be sworn in as a member of parliament. This gentleman defied the court order, went to the chamber of parliament. Look at the confusion that was occasioned there. We all witnessed it. Post this matters, the High Court settled the matter and said that, look, as it stands now, I have declared your elections a nullity. Go and rerun the election easy. Immediately thereafter, then they filed an appeal. On the back of the appeal, a stay with execution was filed. That tied the hands of everybody in the matter. Instead of pursuing the appeal, The appeal was never pursued by the lawyers of Mr. Quayson. They kept filing different applications on the back of the stay, and the appeal that was filed at the Supreme Court and in the Court of Appeal. Thankfully, as it stands now, because they could not meet the condition of appeal, everything has been struck out. The appeal was struck out. All other processes pursuant to the appeal, which was filed, have been struck out. So now, there is nothing at the Court of Appeal. Another case was filed at the Supreme Court, because at the time it was filed, there were matters also at the High Court which had not been dealt with. Thankfully, yesterday, the Supreme Court, if you look at the ruling carefully, you will see that the court cannot close its eye to the fact that there is a valid judgment of a High Court, whose judgment has not been set aside, whose judgment is still a valid court.
But of course, Gary, we know that a High Court's decision can be set aside by the Supreme Court. I mean, let's not make it appear as though once the High Court had delivered a ruling, the Supreme Court had to do the same line.
If you listen to me well, you will understand what I'm saying. What I'm saying is that as we speak, no superior court other than the High Court, all right, the Court of Appeal, the Supreme Court has not set aside the decision of the High Court, and therefore the decision of the High Court is binding. And my little president, he understands. Ex parte for that. If a judgment of the court is delivered and you disagree with the judgment of the court, you might take to set aside the judgment of the court. As it stands now, the judgment of the High Court is the only judgment affecting the decision in Assin North.
With that same case still pending at the Supreme Court?
Say it again?
With that same issue still pending at the Supreme Court? The substantive
what I'm saying is that the judgment of the High Court affecting the issues in Assin North, as determined so far, is still valid. It's not been set aside. That judgment is what is there now. And the court, in granting an application for injunction, cannot close its eyes that the judgment doesn't exist, and therefore continuously, continue to violate the order that don't go to the Parliament. The order is there already. That you have been restrained from going to Parliament. It is there already. It's a relief, which was granted by the High Court, and yet he still goes to Parliament. That is the crux of the matter. So if you look at it carefully, you will understand. You will understand why the Supreme Court, per the majority decision, could not close their eyes to the pendency of a valid judgment of a High Court.
One of the matters raised by Roxanne Nelson Dafiamekwa, we'll get into other details of this ruling, but he makes mention of the fact that certain constitutional office holders cannot be injuncted, so to speak. Like Mr. President, there are certain things you cannot do. And he extends that and says that in this instance, it was wrong, the decision of the court to injunct James Quayson in this way, because I mean, you are fully aware that when it comes to injunctions, it is to create some parity. So one side may have an advantage that must be leveled out against the other party. But in this instance, he talks about Mr. Nimfa, the applicant, and all of that, and the fact that he stands nothing to lose. The biggest loser here is the Member of Parliament for Assin North, James Quayson, who now cannot perform his parliamentary functions, though technically he still is a member of Parliament, and maybe his constituents. That is the argument of Roxanne.
Yeah, my brother my brother, Mr. Roxanne, the firm point to you a single statutory breach, or let's say a rule of practice that says that the MP cannot be injuncted. Which law is he relying on?
Go and read NLA versus Ghana Lotteries.
Hold on, Gary. He's doing exactly that.
Go and read NLA versus Ghana Lotteries. All those chain of cases. NLA versus Ghana Lotteries. My brother, go and read it.
No. Are you saying that a member of Parliament cannot be injuncted by any law in this country? Is that what you're saying?
Yes, you can't injunct him.
I disagree with you. You see, the point we make.
Give me the authority. I have given you authority. Give me the authority that says that you can injunct.
All right, Roxanne, hold on. Let's hear from Gary as well.
Roxanne, you see, the point you made very clear. That the Supreme Court by 5-2. In fact, even with the one that I read, that is one of the authorities, one of the judges that I read, she simply said that, look, there is a judgment already in force. So she does not see why you should come with an injunction application. You simply go and enforce the judgment of the High Court. So technically, that is not even amount to refusal of the application. So please.
You're not addressing.
But quickly, Gary. Can you give me? He has given. Oh, hold on, Gary. Hold on for me. He has given some authorities when it comes to the bit about not injuncting constitutional office holders. Do you have authorities that speak to the contrary?
The authority in point is authorities the Supreme Court has just cited and delivered a ruling on.
Sorry?
The court could have been wrong or close its eyes to any other authority, but it comes to the conclusion that the injunction is well laid.
In this instance, we have two dissenting opinions. It's not a 7-0 ruling like we had in the Justice Abdullahi case. Does that not let you think, I mean, once there's an obiter or more, that this decision itself is questionable?
How is it questionable? I mean, how can a decision be questionable? I mean,
I'm just saying that in legal terms, if you don't have a unanimous decision, it means there is room for some sort of review or a reversal, if you like.
No, the fact that you go to court and you have even 5 justices on one side agreeing and two dissenting. As I said, even one of the dissenting opinions, the point that she made was that, in her view, the judgment of the High Court was subsisting and that they should go and enforce the judgment of the High Court, i.e., to go and rerun the election as saying off. That, in her view, the constitutional matter put before the Supreme Court will only be a matter of academic exercise. I have read it. So what I'm saying is that, as it stands now, if you have 5, even 2, it doesn't question the judgment that because it's 5-2, you will say, well, there's a room for what to review. Well, they can try review. Maybe the court may change their mind. Maybe the court may not change their mind. But the bottom line is that, as it stands now, Mr. Quayson has egregiously been going to Parliament when, in fact, the court said he should not go to Parliament.
Now, of course, he was elected, in that capacity. But let me just, get your take on this. So you agree, technically, that James Quayson is Member of Parliament, remains Member of Parliament for Assin North, but he has merely been stopped, if you like, from carrying himself out as such within this window or within this period and acting upon same in Parliament. You do accept that he remains, for now, the Member of Parliament for Assin North?
Yes, until the Supreme Court bring finality to the case before it. As a matter of fact, if there was no case before the Supreme Court, the High Court judgment will have ended the matter. But because they themselves, want to Roxanne, why do you keep interrupting? I think that is very
I've told him to hold. I'll give him ample time to respond. So Gary, go ahead.
Yes, what I'm saying is that after the judgment of the High Court, if they had not filed any stay or any appeal on the back of the stay, and with all the plenty of applications they filed the Court of Appeal and the matter ended the High Court, then reasonably that would have been the end of the case. And because of the numerous appeals they kept filing, and yet they failed to pursue the appeal.
Right.
You see, that's where they should be the blame. I think they should even ask their lawyer why he failed to comply with the condition of appeal in the first place. Because if you are signed with the Form 6, you must take steps to file your submissions. But they didn't do it. You see, so I don't know why they sometimes blame the court when, as a matter of fact, the blame should lie squarely on their back door or their doorsteps. So clearly, as it stands now, I hold a humble view that in view of the pendency of the matter at the Supreme Court, Mr. Quayson, yes, will remain a member of Parliament, but cannot go to Parliament because he's been injuncted.
Okay, let me just run this by you. Do you think that on the back of this injunction, with the substantive matter still pending before the Supreme Court in terms of the constitutionality of his election, a by-election can be conducted by the Electoral Commission?
Say it again.
So I am saying that on the back of this injunction, which is on a separate part of it, his holding himself out as a member of Parliament, that is what it bordered on. Do you think on the back of this, with the substantive issue of the constitutionality of his election still pending before the same apex court, the Electoral Commission can go ahead and organize a by-election. Is that possible?
Well, I think that the EC will have to hold on and let this case be brought to finality by the Supreme Court in an expeditious manner, so that post whatever the Supreme Court says, it will advise all of us the direction to go, whether to go left or to go right.
I find it curious that you say that, because Attorney General, Minister for Justice, Godfrey Abuadame, said yesterday that the Supreme Court now has the green light, so to speak, and that it can go ahead on the back of this decision of the court to have the Electoral Commission can go ahead and organize a by-election.
The Attorney General said that the Supreme Court has ordered expeditious hearing of the matter.
Right, that we heard.
Yes, so by and large, by extension, whatever he is saying, it simply means that we all wait to abide by what the Supreme Court is saying.
But that is not how he couched it. He said that basically the green light has been given and the Electoral Commission could go ahead and host a by-election. I just want that clarity. Is that possible? It's not possible now, is it?
That is my understanding of what the AG said. That the Supreme Court has ordered for expeditious hearing, ordered all parties to file their submission before the court.
Right.
And so therefore, all parties must abide by it, file it, get the court to determine the case one way or the other, and that will guide all of us the conduct of the matter going forward.
Have you considered, and gentlemen, let me apologize to the rest of you. I'm doing this because of distance and the fact that at least Gary is with us and the internet connection could be patchy. So I just want to quickly do this with him so that if there are any interruptions, at least we would have got the scoop on there. Gary, so have you sat down to contemplate the impact of this on the constituents of Assin North? Have you considered that?
Yes, we have.
And do you feel it is right on the back of what Roxanne says that constitutionally you shouldn't injunct a constitutional office holder? Well, let's set that aside. But right now, you've put the people of Assin North in a situation where they have a representative, but
they don't have.
De facto, they don't have a representative.
We hold a firm view. And that view is very dear to our hearts. That is better to get somebody who is qualified, who is eligible to represent the people of Assin North, than to get somebody who, in our view, that's our view, which has been endorsed by High Court judgments, that person at the time when he filed, was not qualified to have been, to have filed in the first place. And that is a very clear matter. You see, it's a case that I conducted with Mr. Tabaklo, ex-parte Senator Ajima Rollins. And they are happy referring to that case when it comes to that particular matter. Yet when it comes to this particular case, they say, no, don't refer to that case.
So they are picking and choosing.
The Supreme Court made it very clear that all the eligibility criteria, it kicks in when EC opens nomination. Question, when did EC open nomination for the filing of parliamentary elections in Ghana? Between 5th to 9th of October 2020, all right? Now, at the time when EC opened nominations, Mr. Quayson was holding on to the Canadian citizenship. He had not renounced. He got the citizenship renunciation on November 26. These are facts. So when they run away from ex-parte Senator Ajima Rollins in this case, I struggle to understand why they are going that path. Meanwhile, in that particular case, the court was very clear that all the criteria for eligibility and qualification will kick in at the time when EC opens nomination. So let's get the point very clear. That's what we are saying. That's what we are saying. So we are saying that let's get somebody who is qualified to represent the people of Assin North, no problem. But we consider all the factors. We cannot allow people who have obeyed the Constitution to stay in Parliament. And when the High Court has given injunction, the gentleman beat the injunction order, came to Parliament, sat in Parliament, created confusion in Parliament, and we all saw it with our eyes what happened in Parliament, the chaos in Parliament caused by this particular gentleman.
Gary, so do you foresee from where you sit, looking at the legal facts before you, do you foresee that the Apex Court would corroborate what the High Court gave in that earlier ruling and basically quash the election of James Quayson, starting the process for a by-election?
I will be happy. I will be happy, exceedingly happy, if the Apex Court endorses the view that we hold, and then comes to the conclusion that, as far as they are concerned, Article 94(2) is in pari passu with what the decision they took in ex parte Jonathan Rollins. I'll be happy if they come to that firm view that that position that they took in that case, which are conducted, is the same position they are going to take. I'll be happy if they depart. That one I cannot tell. But I'll be happy if they take that view. If they take that view, it simply means that we are.
Do you foresee that they will? Do you foresee that they will? Just briefly, yes or no? Do you foresee that they will on the trajectory that they are following so far?
The court can at any time depart.
All right.
For me, so sometimes, if you say you are going to foresee, it means that you are seeing something beyond what you can see. They can always depart based on the facts and the circumstances. But I'll be happy if the court, goes by its own decision in ex parte Jonathan Rollins and then says that, look, criteria for eligibility and all it kicks in at the time when EC opens nomination. If that is so, then between the 5th to 9th of October, the question is, was Mr. Quayson a Canadian citizen at the time or not?
Okay.
That's all.
Right. So we've overflogged that horse. Just hold for me, Gary. Stay with me. Stay with me, Gary. Stay with me, Justice Abdullahi. I shall come to you. I'll give you a fair, amount of time to, address these issues. And Roxanne, I hear you in the studio as well. I'll come to you. But let me bring in Dr. Rashid Draman, who, of course, is one who stays with these parliamentary affairs. Dr. Draman, thank you for joining the conversation. On the back of this latest ruling by the Apex Court, what is your understanding of the core issues? Now, James Quayson, the Member of Parliament for Assin North, has been injuncted. He cannot hold himself as such. How does that rub off on you? Right decision?
Well, I saw this coming, given all the discussions that, have taken place in the media, and then given the history, of course, when I say history here, talking about the second day issue many years ago.
Right.
I think for me, I saw this coming. I don't know the legalities involved. I'm not a lawyer, but watching Parliament carefully, and particularly watching the balance of power situation in Parliament, in the 8th Parliament, I didn't see a different outcome from what I saw yesterday.
So you sort of saw this coming. What made you think that the court was going to rule in that direction?
First of all, I think there is... Hello?
I'm listening to you, Doc.
Yes. First of all, I think because of the history that I referred to earlier, and then secondly, I think from that history, for me, I thought that the political parties, I don't know whether both parties, but at least I thought that maybe the NDC did not learn, some very serious lessons. I know the MPP learned some lessons from the secondary matter, because I know a particular instance when somebody was going for to even file to contest for primaries within the MPP, and he was told that, look, we need to see clear renunciation of your citizenship before you even contest the primaries. In the case of the NDC, I don't know whether they learned any lesson, and they left the situation to a point where we even had to get to the election period. And
so that was a flaw. That was a mistake by the NDC, from where you sit.
I would say, from where I sit, that might be a mistake. Even though, let me just be very quick to add, because I have a lot of affiliation with Canada. I studied in Canada I have relatives who are Canadian citizens. And during the COVID period, I was caught up in Canada. And I was, told that the processes regarding immigration issues, all of a sudden because of COVID, have changed dramatically to the extent that if you had to wait to get a document from immigration, maybe normally for maybe 3 weeks, it had turned into about 10 weeks and so on. And, well, from my little knowledge of Canada and the processes, I was, thinking that might be what created this difficulty for the honorable member. But I don't know whether the court, took that into consideration. But however, we break it. At the end of it, I'm just thinking that maybe the NDC did not learn some lessons from the second day saga.
Right. The bit about injuncting a member of parliament in this way, how do you feel it impacts our democracy and, of course, parliamentary affairs? What do you feel the impact is?
Well,
because, and let me just add, because Roxanne Nelson Dafiamekpo, the member of parliament for South Dine, for example, says that under normal circumstances, you shouldn't be injuncting constitutional office holders like the president, among others. And he cites some cases, the NLA, you cited? The NLA
yes.
versus
Ghana Lotteries.
Right, so the NLA situation. So how do you react to that?
Well, I come to this from a point of view of representation, which has been one of the weakest links, if you like, in our parliamentary discourse.
Right.
Over the years, there have been complaints about absenteeism, there have been complaints about MPs not going to their constituencies and so on. You put all these together, it's related to, us, constituents not getting properly represented.
Right.
So if, an MP is injuncted and then not allowed to perform his or her duties, it simply means that, the people of that constituency, for that period of time, are denied an important aspect of our democracy. In fact, representation defines our democracy. Because at the end of it, we can have, the judiciary, we can have the executive running, but, if we don't have representation, then we cannot call ourselves a democracy. So if you deny a member of parliament from performing his or her duties, it means by extension, those people that he or she represents, I think, are denied a voice around the table in the House of 275 members.
So you side with the minority who say this should not have been done because it is unfair to James Quayson, it is unfair to his constituents who now do not have a representative in parliament, though they actually do have one, but he cannot exercise any role in parliament. You feel it unfair to them?
Yeah, I don't side with any group. I only side with the issues that I'm very familiar with, which is the fact that I think representation is weak in our parliament. We see it every day, and you come and add this to it, means that particularly the people of Assin North are doubly affected, and I think that's the way I want to look at it.
Right. And so for now, as it stands now, that is the decision that has been adopted. I do realize that in this instance, we have, and some of the matters we've discussed in the past, we've had unanimous decisions. Finally, maybe before you let go of us. In this instance, we have a 5-2 decision. What picture does that paint for you, the possibility of a reversal of this,
Yes, I was very pleased. Unlike, I hear Justice Supply sitting there with you, unlike the matter that he took to the Supreme Court where there was a unanimous decision, I think in this particular instance, I was pleased to see at least some dissent because, look, I think, that's what we expect. And so that at least there is some room for, some argument, one way or the other.
Dr. Rashid Rahman, thank you for joining the conversation. Executive Director for the Africa Center for Parliamentary Affairs. Let me bring in Justice Abdullahi. You are familiar with this terrain, with the case in court yourself that you're seeking review for. But what is your reading of this recent ruling of the Apex Court on the back of Assin North?
I must admit that is as Dr. Dramani said, it was expected, considering the fact that the basis upon which all these subsequent suits were mounted were the High Court decision. And the High Court decision was appealed against, but the appeal abandoned, for which reason it was struck out. So really, it left very little to hold the honourable member from still being in Parliament. And so this wasn't a surprise. I'm not sure, even to the media, this was any surprise sent to you because of the circumstances. Now, having said, I am still of the opinion that notwithstanding all those things, we could have allowed the Member of Parliament to continuously perform his constitutional obligation, considering the importance of his office. And
even if it would have impinged on the law, if legally speaking, and that is why we've had election petitions in this country. If someone is exercising power without being clothed with the right to exercise that power, it is wrong. And in the election petitions we've had, for example, that is why we've had to go to court to clarify that, people can actually do what they're doing.
You're 100% correct. The only problem with this one is that there's no finality yet. And so, as far as I'm concerned, this decision could tilt, as Gary admitted. And so, even though I can understand the fact that some people call him a walking illegality and we cannot allow an illegal person to be in the House of Parliament, I admit, unfortunately, that notwithstanding, there is still no finality to this issue. And that finality could completely throw everything that we're discussing off the record. And so we should, as far as I'm concerned, we should have allowed him to continuously perform his duty and then go by the Supreme Court's decision to pursue whatever remains with that level of swiftness, just so that the people of Ghana in general could have some sense of justice and also take away this whole idea of an illegal Member of Parliament being in Parliament. Because really, I think the cost of not having that Member of Parliament in the House far exceeds the benefits that we derive for having him out of Parliament.
Wow. It's a crucial point. It's a crucial point you make, Justice Abdullahi. You're saying that the cost of not having James Quayson in Parliament far exceeds whatever gains or boons or benefits we may get from his not being in Parliament and supposedly curing a defect of the law. That is what you're saying?
Absolutely the point I'm making. And here I'm not only referring to the financial gain. As for the financial gain, remember, because he remains a Member of Parliament, he will still pay him anyway, even though he will not be performing any parliamentary duties. He will still pay his entire emolument until such time that his whatever pence now is completely thrown out. Now, this is just the financial aspect of it, if you look at it only from an emolument point of view. Now, the other side is the services that he would have rendered as a Member of Parliament. And second, not just as a Member of Parliament, also as a supervisor of the executive and indeed all other arms of government. This cannot be quantified in monetary terms. These services, whatever the intellectual capacity that he brings on board, we are literally throwing that away because of some other expediencies. And I cannot see my country going through that when I have a resource person like that spending his time outside of Parliament when, in law, he remains a Member of Parliament. But because of particular circumstances, we cannot buy into his ideas, we cannot buy into his intellectual capacity, and we just allow him to rot while still paying him. I do not see how this benefits us in any way. I can't see how that benefits us. And this is the reason why I'm of the strongest opinion that at least solely on the basis of these two main grounds, he should have been allowed to continuously perform his parliamentary duties until such time that the Supreme Court comes to a conclusion on as to whether or not the entire circumstances surrounding him was illegal or unconstitutional, and for which reason he should be thrown out of power.
Do you feel then that, based on technicality, the Apex Court erred? Do you feel they have robbed the people of Assin North, and I use my words carefully, robbed them of the right to representation?
I wouldn't put it in that context. I would put it this way, that the Supreme Court could have done as better, not Assin North members of the constituency. The entire, remember, he may be representing Assin North, but he's serving the entire nation. And so it's a nation that loses from his absence or presence. And so if you look at it from that angle, from where you're putting it, I think it may probably be a bit unfair to the Supreme Court, because the Supreme Court also, of course, took the decision they took based on the processes before it, and then, of course, and the understanding they had of the issue. But it would be very difficult to say that the Supreme Court was wrong in that angle. But
so isn't it convoluted? It's pretty convoluted. You're saying they are not wrong, right, but you disagree with them and you feel they didn't do right. I mean, what is it?
That's what I'm getting at. I'm saying that. No, I just don't want to use your words. I'm saying that the Supreme Court could have done a far better service by retaining him in office than throwing him out. That's all I'm saying.
Right. So do you feel, just to put it very briefly, so do you feel the court, because when you read the decision of the court, it paints a certain picture. Very quickly, do you feel the court should have averted its mind better to the consequences on the constituents, which may not have happened?
I think in summary, that's all I'm saying.
Okay.
That the societal benefit, the political benefit, the national benefit, the interest of the nation exceeds the private individual, the private interest of that individual member of parliament. And so for that reason alone, we should have had him in office.
What are your expectations moving forward on the substantive issue? And if you could advise, because there are those who have said that the legal team for the Assin North Member of Parliament should go for a review. In this instance, we have a 5-2 decision. What advice as legal counsel would you have given?
A review application for me, you do it on the basis of principle, not because you think the Supreme Court is necessarily wrong. Because really, as we all know, including my own case, which I may not be able to bring out now, a review is a very difficult thing to do, and in addition to the fact, particularly when, in fact, sometimes, even where the Supreme Court was palpably wrong, they will still refuse to grant a review application. However, on principle, it would be better to apply for a review, because of that small room of opportunity that you probably could have explored to tilt the balance. And if that room still exists, and in this particular case it exists for the Member of Parliament, I will strongly urge his legal team, and I trust the members of his legal team, that if they believe in their case, I will strongly urge them to do it. Even if they don't believe in their case and there are now grounds for them to apply for review, I'll strongly urge them to do so because of the interest of the nation. Not particularly because of the interest of that Member of Parliament, but because of the interest of the nation.
On the substantive issue, could we see a divergence in terms of opinion, in terms of the constitutionality of holding his office on the back of how things have gone? Very briefly, so I come back into the studio to Roxanne.
Well, that I may not be competent to advise because really he has a lot of senior lawyers, and in the likes of Roxanne is himself there, among others. I think they are better placed to expect what they are up against, and they know what to do better. But also when they have the full facts of the case before them, so they know better what to do and how not to do what they want to do. And also, of course, they understand the political implications of everything they do. But I would always urge that we should look at the interest of the nation in making some of these decisions, and not to leave any stone unturned in the pursuit of justice. All right.
Justice Abdullahi, we're grateful that you took the time to join us this morning. We'll see how matters shape up in court. Let me come back into the studio. You've been quiet for a while on account of, yes, we've had so many divergent opinions. Yeah. You've heard Gary Nimakun, yes. You've heard Dr. Rashid Rahman, you've heard now Justice Abdullahi.
Yes.
Putting all of these into a nutshell, what are your quick reactions? And moving forward, what can we expect from your quarters as the NDC?
First of all, I find favor with Justice's argument. I strongly align with its submissions and adopt all that as if they are mine. Now, Gary continues to speak of a high court decision, and closing his eyes to the fact that that high court decision is being impeached by an appellate process. Is Gary saying that today, when an appeal has been struck out for mere non-compliance, that is material? It is not. It is something that happens all the time in the appellate stage. And what the party has done, what the appellant has done, what Quayson has done, is that he has applied for releasement. How is that not important? That an appeal that has been struck out for non-compliance, he has applied for releasement. And he's glossing over it as if it's not something that we do all the time as practitioners. That's one. Two, Quayson has also petitioned the CJ's office regarding the disqualification of the president of the panel of judges that are hearing the appeal. How is that also not important? So they speak as if he's not in court, exercising his rights under the Constitution. He's in court. The matters are not terminal. So when they speak of a pending high court decision, why, as a lawyer, if somebody defies the court's ruling in terms of an interlocutory injunction, what do you do? Why didn't they cite him for contempt of court? And they are making fetish out of this matter. So we are simply saying the substantive matter in respect of the election dispute is in court, it's at the appellate stage, it is not terminal, it is pending, there are processes on file. As regards the December 13 case that has been filed,
right,
based upon which the ruling was delivered yesterday, I am saying the court has done an injustice to Quayson. And I agree that they should as the legal team, should be able to apply for a review, even before the matter itself is determined on its merit. You see, the Supreme Court is the highest form of distorting the law. So when they do things and you disagree, you go back to them. There are a plethora of decisions where the court has departed from things that they have said before. So it is not correct that when they give a ruling and you disagree, and we think that from the way Abdullahi ventilated the matters, there are political consequences, there are governance issues, there are oversight issues that Parliament exercises. So on the balance of the equities, the state will suffer more.
The state will suffer more.
Will suffer more
on the back of this decision.
On the back of this decision, vis-a-vis the de minimis nature of the right of the plaintiff, who is seeking constitutional interpretation. If the court makes a pronouncement, and so what? The court will be making a declaratory judgment that pursuant to so and so and so, we interpret the constitutional provision this way. So what would the plaintiff then do? Now, let me also offer this education. When you file your nomination form with EC, it is a declaration of mere intentions. It is a mere declaration of intentions. You can actually withdraw your nomination. When you withdraw your nomination before 7th of December, you are merely a candidate.
Right.
You don't go through even when you win the election, you are not an MP. In fact, our laws have no regard for you. You have no role in our laws. So, because there would have been a sitting MP whose term would have been expired. That is why when something happens terminally to somebody who got elected and before he is sworn in, what the electoral commission will do is not a by-election.
Right.
They will simply hold another election. So it's important that when we are making this argument, we factor some of these things into play. You only become a member of parliament when you take the oath of office, the oath of allegiance, and the oath of a member of parliament. So for me, it baffles me that somebody will say that at the time that Quayson got elected on 7th December, he owed an allegiance to
So you dispute that?
I dispute that. And we've been asking them to bring the evidence. They can't provide the evidence.
Hold for me, Roxanne. Gary, let me bring you in on this. He is alleging that you've not even been able to, provide an evidentiary basis for this claim. How do you react?
You see, let me make this point. That you see, my friend sitting there.
Gary, maybe you could speak up a bit more for me. I'm struggling to hear you.
Sorry.
Right.
You see, my friend sitting there, Roxanne, he's my very good friend.
I'm not your friend.
Let me make this point. You see, what you made.
You don't put a dagger behind me and call me a friend.
Oh, Roxanne, please. Don't distract me.
Roxanne, so let Gary go ahead.
You see, Roxanne is not laying any blame at the doorstep of a legal representation of the Assin MP who failed to pursue the appeal. He is very silent on that. 2, he says that they filed for reenlistment. Reenlistment simply means that, as it stands now, there is nothing at the Court of Appeal. 3, the fact of filing for reenlistment does not mean that application will be granted automatically. It doesn't mean that. You have to explain to the court the rationale or the basis why the appeal itself was struck out. So when you file for reenlistment, it does not mean that there is anything for the Court of Appeal. There is nothing there now.
Don't we have a motion for reenlistment, Gary?
Now, a motion for reenlistment is not automatic.
Thank you. I know that.
The court can still refuse it.
But that is a process before the court.
Yes,
is it not?
But there is no appeal before the Court of Appeal.
Gary, reenlistment is a commonplace motion we file all the time.
What I'm saying is that the file of the mere file of reenlistment application does not mean.
So I think I get both sides. Gary is also making the point that it is not automatic that once you do this, it will culminate.
But it's something automatic in court.
Right.
It's something ever automatic in court. You always will have to persuade the court.
Gary, go ahead.
That's why I'm making the point. I'm making the point that as it stands now, there is no appeal before the Court of Appeal. The judgment of Assin North in the High Court has not been impeached. It has not been impeached as it stands now, because there is no appeal on the judgment. There was no stay of execution on the judgment. There is nothing. Now, can the Supreme Court?
There was a stay. There's a stay.
Roxanne, just hold for me, Roxanne.
Roxanne, I think that.
Go ahead. No, Gary, it's okay. Just go ahead.
You miss practice. Now we do it because we've been battering each other in court all the time on the other side. So I think he's missing practice. You see,
I agree with you.
The Supreme Court could not in any way close its eyes to the pendency of a subsisting judgment. It could not have done that because it's a superior court. The High Court is a superior court, and it's a judgment there saying that you are forever barred from holding yourself out as a member of Parliament.
Okay.
And it's an offer for rerun. Let's also forget that this current case before the Supreme Court was not filed on the back of the High Court judgment.
Of course.
These are the 2 independent cases. It wasn't filed on the back of the High Court judgment. However, in the application for injunction, the lawyers exhibited the judgment of the High Court to show the Supreme Court judges that, look, my lords, there is a judgment already in place which is being defied. And the court could not close its eyes to the judgment of the court because the Superior Court judgment. Now you say, why do you have contempt application? Yes. Contempt, people have done so.
Before him.
Okay.
People have done so.
Right.
People have done so. But for very good reasons, we decided not to pursue that path. So the fact that we didn't pursue the contempt application does not mean that the lawyers couldn't have done that.
Okay.
For very good reasons, which I will not disclose. But let's all understand this point.
All right. Hold for me, Gary. Hold for me, Gary, on that point. I want Roxanne to come in. Roxanne, what's your take?
Yes, my take is that at the time that the matter was filed in December, The appeal was pending.
Right.
At the time that they filed the motion on notice for the grant of the interlocutory injunction, the appeal was pending. So when Gary says that they exhibited the judgment of the High Court, at that time, the judgment has been stayed. So on what basis were they exhibiting it? To hoodwink the court?
Did you say to hoodwink the court?
Yes.
You see, Rosin.
Yes.
I beg you, take your time and read the ruling. You see, you will realize that in the ruling, whilst on his seat, Frank Davis Esquire indicated to the court that there is no stay application at all. Also, the appeal has been struck out. Lead counsel for the first defendant respondent, Mr. Chachuki Chikata, was in court. And the judge is saying that he did not oppose that submission. Even though there was no exhibit before the court to demonstrate that, yes, the appeal had been struck out, he did not oppose that submission, which means that the submission was correct. So why are we now standing here on the television to come and say that what has happened is like what we are saying, we are rather wrong? Those who were in court.
I am not sitting on TV making claims. I'm saying that at the time you filed the motion and you claim that you exhibited the High Court judgment, there was a stay. The motion was moved after the striking out of the appeal on grounds of non-compliance, which motion for releasement has since been filed.
Gary, do you get the point Roxanne is making?
I don't get his point. It's just being mischievous. All that is happening is that at the time when application for injunction is being moved, the court will seize all the material facts with all the exhibits attached to it. Okay? And then the court says, so far, these are the evidence we have before us. It is a judgment of a high court, which judgment clearly is still subsisting. It's not been vacated.
Okay. Right.
That's the point that you see, until a judgment of a superior court or any other court is vacated, appealed against, or set aside, that judgment must be respected and obeyed.
Okay.
Ex parte affoda.
Right.
Ex parte affoda.
Gary, Gary, just hold for me. Hold for me. I want to do this. Roxanne, you're a member of the legal team of the NDC. Of course, we have those who are representing, in this case, James Quayson. On the back of, and you've complained in the past about the fact that there are always unanimous decisions against you. In this instance, it's a 5-2 decision with some 2 dissenting opinions. Does that give you hope that you can overturn this injunction?
Yes, I am of the humble view that the basis.
Pardon me.
This one we are speaking law.
Right.
I'm on the humble view that the basis of the grant of the injunction, torpedoes are settled law on this matter. So I think that upon a review application, the court may reconsider its position in respect of the office holders or the office holder in question.
Yesterday, listening to, I believe it was Baba Jamal, we had such, a premonition, or at least thinking along those lines, that you just might toe that line. Will you actually, is that the plan, to actually go that way to seek a review?
Yes, I think we should do that.
I'm not asking what you think. I mean, as a party, are you privy to any such information that you are going to do that?
We'll give the advice. The party will have to take the decision. It's not really even the party, but the member of parliament will take the final decision. The party will back him, but he has to make the decision. And like we're all saying,
from where you sit, is James Quayson willing to push that far to seek
I think he has. I said yesterday that he has rights under law to pursue every legal remedy available to him, including the right to seek a review of the grant of the interlocutory injunction in the matter, because it affects his rights as a member of parliament. He's not been removed. He's only been injuncted.
There's also the issue of Roxanne, and it's raised by a member of parliament for North Tong, Samuel Okudzeto Ablakwa. He says the MPP knows how to play this game and that they've played it well. And he's saying that, but instead of giving them one by-election, and I feel the way things are going, whether now or later, we just might come to that point. Instead of giving them one by-election, why not give them 4? Give them one to do with the Member of Parliament for Ayawaso Central, also Regional Minister for Greater Accra, Henry Kwate. Give them Saradwa Safo Domekwa Abenya and then give them Assin Central, close to him, Assin North, Assin Central, Kennedy Japan. What is your take on that? Do you agree?
Fair is fair.
Fair is fair.
Yes.
Gary, I see you laughing in the background. What are you saying? 1 versus 4.
After saying of Roxanne, and Tamaklo, there have been discussions every time on the background. And they know what they are doing. They know what they are doing. But for me, I would think that in the face of what has transpired so far, and the fact that this is not the first time we have seen this in our country. I mean, second day, similar thing happens second day, and I think the MP himself was not willing to push the matter. I can't blame him. You see, when you're in a political party,
second day is materially different.
The whip system sometimes works. Now he's being forced to be whipped in line. But the difficulty is that if the criminal case catches his leg, he will have a problem. Because now there are 2 cases running side by side. The criminal case and the civil case. So I will not say anything for now. When I meet Roxanne, when I come back home, we'll go and sit at our base and we'll have our discussion. That's what we usually do. But the bottom line is that they know very well. They know. On the TV, they will not tell you. But they know that on Assin North, they saw all the documents before all this happened. And they didn't, there's an inaction. That's the reason why even the appeal, they didn't pursue the appeal.
It cannot be so. Gary, you are being mischievous. It cannot be so.
You file an appeal, you file stay of execution, you file further application on the appeal. Why don't you file your submissions and let the court of appeal determine the appeal on its merits?
Right.
Why? And you abandon the appeal and you get to this stage and then you are now complaining. I don't understand. The complaint or the blame should be laid at the doorsteps of the lawyers for the NDC who are doing the case for the Assin of MP.
Okay.
But they should be blamed.
Gary, our rights are not exhausted. Why are you making this argument? Is our rights exhausted?
Assuming they have written the submissions and had the court of appeal determine the matter on its merits, we won't get to this stage at all.
Let's cap off the conversation.
I
saw an interesting comment.
Has the opportunity to determine the appeal.
I saw an interesting comment come through, and it's just a bit of I'm trying to get it, but the person was basically suggesting that in this country we're trying to get people to switch nationalities, or better still, people who are dual nationals, we're trying to get them into our football team, senior football team. But at the same time, when it comes to our politics, we're pushing them away. But
let me even
conclude,
let me even support you. We have a member of parliament, Kennedy Osenyaku, has a private member's motion, in fact, bill, to amend the constitution to enlarge the number of public office holders under the dual citizenship provision. MPP. You are here tackling Quayson.
Okay, so I want your concluding comments, gentlemen. I'll start with you. I'll start with you, Gary, and then wrap up in the studio with Roxanne in just about a minute, if you can. Your concluding comments, but also in the instance of broadening our democratic practice as far as Parliament is concerned. The 3 MPs who have been cited. How do you feel? I mean, things should move to give us that sort of.
I think that the 3 MPs, yes, they are 2 people in the privilege committee. To go and show cause. So if you go there and show cause, I mean, I've heard Honorable Japan saying that he has medical report to show that, yes, indeed, it was outside of the jurisdiction, but of course, you should go there and show the cause. Once you show the cause, they will know that, well, it wasn't out of deliberateness, that is why he was not in Parliament. And then the other 2, they should also go and show cause. That is all I can say on these matters. But the other one is where we have a difficulty with, but that one I won't make any comment on it.
Which other one? I said no.
I won't make the other one.
Or Dominic Wabenya.
Well, I believe so. I will not comment on that one because of my former familiar relationship with the person as a partner in Chambers. Now, on the issue of finality on this particular matters about the ruling yesterday, I think that it is fair, it is proper. It has, enhanced our constitutional democracy.
Right.
It is going to ensure that in as much as, or in as far as there's a judgment subsisting and it has been vacated or set aside, no court can just close its eyes and say that, look, it is just going to, he said, well, there's a judgment there, but we're not going to look at it and enforce it.
Okay.
That can mean amount to the court itself,
All right.
More or less egregiously breaching its own, rule of law.
Gary.
So I think it's cool. Roxanne, we'll meet on Monday at the location.
Okay. All right. Gary, thank you so much. Gary Dimako, the member of the legal team of the NPP. But let me bring in Roxanne on the other end. I'll be fair to you, a minute and a half. We have to go. Roxanne.
I'm restraining myself, but I think this ruling is anti-constitutional.
The ruling of the Apex Court is anti-constitutional.
As an interlocutory ruling, it's anti-constitutional. To ask to injunct a member of parliament, not removing him from office, by asking him not to exercise the functions of office, is anti-constitutional. The spirit and letter of this constitution doesn't give way to that. It does not.
That is why they stuck to the letter, but maybe not the spirit?
Yes, and it's also wrong. That is why when you are elected the president...
I mean, this is just a thought.
Yes, when you are elected the president and the election is in dispute, you are not injuncted from exercising the powers of the president until the final determination of the matter.
Like we've seen before?
Yes.
Right. Okay.
You are not injuncted. Well, so for me, it's anti-constitutional.
Roxanne, thank you. Thank you so much for joining us.
It's my pleasure.
Roxanne Nelson Dafiamakwa, whom you just heard, Member of Parliament for South Dine, also on the Constitutional, Legal and Parliamentary Affairs Committee of Parliament. Gary Dimako with the legal team of the MPP. Thank you, Gary. We also had Dr. Rashid Draman of ASEPA, and at a point in time, we had others, Justice Abdullahi as well, lawyer, join the conversation.